Is that George Lucas? That's not George Lucas. Yes, yes. George Lucas, but I wanted to show you this. Oh, here we go. Let's zoom in on that because this is very important. So this is more like Steam news, not Steam Deck news, but this is Steam news. Valve will see you in court. No, really, Steam just updated its subscriber agreement. Now, I saw something in my mailbox concerning Valve and Steam and updating the subscriber, like what the agreement. I didn't know what it was. All disputes and claims can proceed in court. So they're saying it has something to do with arbitration overload. If you live outside the United Kingdom or EU, you might have had a pop-up lunge into your Steam game today informing you, helpfully that updates to the Steam subscriber agreement that has affected your consumer rights. Valve is removing both its class action waiver and forced arbitration clauses for affected countries. As the notice reads, the updated dispute resolution provisions are in Section 10 and require all claims and disputes to proceed in court and not arbitration. So no settlements, no cease and desist, no nothing. Just we're going to court. A forced arbitration clause is, as the name suggests, a clause that forces those who agree to a contract to settle disputes by arbitration. Instead of going to court, you and the respondent, in the case Valve, would have several meetings with an independent arbitrator who is then able to give a legally binding award, quote unquote. But then we go down here, and there should be more. What this clause can and can't handle depends on a country's individual laws. For example, in 2022, the United States Congress ended forced arbitration applying to sexually assault cases. Yeah. Yeah, I would say so. I still think of, what is it? Was it Ubisoft Montreal or Ubisoft South America, where a guy sexually assaulted. This is from Jim Sterling's channel, and the guy had had so many cases against him, but he had sexually assaulted his male workers, and he fired people on the spot, yelled at people like, "God, what a place to work at! I'd rather just stay at home." So anyway, but by and large, they considered a tidier way of handling legal disputes. They do, however, often come under criticism for handling a lot of power over handing that power over to big companies that use these clauses. Arbitrations don't typically have juries. Arbitrators can consider apparent fairness over to the exact letter of the law. If you lose the case, it's very hard to challenge. Okay. So why has Valve made this change? I've reached out and we'll update this article. I'm willing to bet this is the person writing this. I'm willing to bet the concept of arbitration overload has something to do with it. So maybe there's just too many. Something's got to go to court. Back in 2020, companies like Comcast and AT&T were ambushed when a few enterprising lawyers discovered that as an alternative to class action lawsuits, people under forced arbitration could simply band together and file the requests for arbitration all at once. As New York Times puts it, many companies, it turns out, can handle the caseload. It's sort of like a real world DOOS attack. This resulted in companies like DoorDash having to foot bills with millions after receiving 6,000 claims. That's a mess. So what they're saying there is that your law firm and all the defense law firms have tried for 30 years to keep plaintiffs out of court. Suddenly, it's not in your interest anymore. Now you're wriggling around trying to find some way to squirm out of your agreement. Turns out that Valve has actually been hit by such arbitration zergs, and recently too, as reported by Reuters, late last year, or Reuters. Valve filed a lawsuit against Zaiger, a small law firm that had alleged antitrust violations on behalf of more than 50,000 customers of Valve's game distribution platform Steam. And in this case, Valve shared a series of slides in which the firm allegedly described the move as a investment opportunity reading. We could immediately begin recruiting claimants to pursue the claims a federal judge has now ruled are well pled and potentially viable, but for such a billion, but for which a billion. That's their bold and Oh, for fuck's sake! I'm not going to read that. So customers have been compelled to arbitration. There's even a website. So it says here at the end, while it's entirely possible Valve has changed its policy on forced arbitration for some completely different reason, I would bet a decent sum that the headache of such a clause, in light of the Zaiger case, is probably part of why the company's doing away with it. So it's accountability, and if you go to arbitration, you don't have to. If there's like billions of dollars or millions of dollars, or if you owe money to customers and you're ripping them off, and you go to arbitration, you have to go to court. But I still think that might be an issue because not every case is exactly the same. I mean, there should be qualifications to just go straight to court. I think that there, I think it's a little irresponsible because not every case is exactly the same. There's cruel and unusual punishment. I mean, you don't want to put a heavy burden on a small case that could be handled in arbitration. I think it should be like, should it go to arbitration? And if not, so if there's arbitration overload, maybe they have to deal with the arbitration cases first. Uh, but I think for Valve, I think they would have to see if a case qualifies for court. And if it doesn't qualify for a court case, then it doesn't go anywhere. It doesn't go to arbitration at all. So you and Valve agreed that all disputes and claims between you and Valve, including any dispute or claim that those that arose before the existence of this or any prior agreement, shall be commenced and maintained exclusively in any state or federal court located in King County, Washington, having subject matter with the jurisdiction. In other words, if you live in an affected country, then Valve will quite literally see you in court and nowhere else. Please, like, so that's Harvey Randall's take on this. So my take is that yeah, it's a very shaky ground with other countries. Uh, I think it's all about the services. So if you have a service, so there's independent people who have their own games that put on the Steam store, and if you're dealing with them independently from Valve, and you're not getting you're getting ripped off, and you have to take them to court, you can take them to court. For the United States, I'm not sure. There might be arbitration still here in the United States, but this is one of those things where whether you're using a Steam Deck, you're using a PC, or a Steam machine, this is great concern. So let's take a look and see what happens in the next few months, and hopefully we don't have any problems. Just stay away from the mobile games. Just get like just open close-ended games instead. Just something simple. Get the Tomb Raider Survivor trilogy on the Steam Deck.